Hello, hello, everybody. Good to see you. Just getting set up here while I'm waiting for people to join. We've actually got quite a few people registered to join today, which is super exciting. So welcome, I'm Danae. I am here to help with your Employment Tribunal questions. If you've got an issue going on at work, if you have issues with your employer, maybe a grievance or a disciplinary process, or maybe you have actually gone further, maybe you're in ACAS, early conciliation. Hi, Abby, good to see you. Maybe you have ACAS early conciliation, or maybe you're even in tribunal, then yes, I would love to talk to you. So let me just get this up and running. So yeah, if you have any questions about any of this, please do let me know. So let's get these lives open. There we go. All right, so yes, hello Queenie, hello Defender, great to see you. Oh, hi Andrea, thank you so much. Union rep here, love your videos. Oh, thank you, that's so good to hear. It's so good, yeah, solidarity with the unions. What industry do you work in, Adria? Very cool. Right, so yeah, I've got a set up on both here and on TikTok and also on YouTube, so hello to both. And as you can see on YouTube, there's always the phone there in the corner. So yes, please do join and say hello and ask any questions that you have. And I will do my best to answer them from the comments. And if you see me looking this way, that's just because I'm looking at questions in a few different places. Okay, so Nomi says, I'm starting a grievance terminating KU contracts in 8 weeks if haven't had them a job. They can't provide. Hi, Seuss. Previous 30 hour in occupational health say 16, and my post can't offer me my job, so said terminating in 8 weeks. I'm not sure I understand the details, Nomi. You're doing a good job of compressing a lot into a short amount of text, but I'm not sure that I understand. Can you finish off with your question? That way I can make sure I've got some understanding. Benny says, tell me this, if an employee sends a strong appeal and then tells the employer to without prejudice, okay, I'm going to wait for Benny to finish their question as well. Okay, yeah, Benny says they're sending the rest. That's absolutely fine. Okay, so Nomi's saying, basically, I've been medically redeployed. Do I have room for a grievance? Okay, Nomi. Right, so it sounds like because occupational health have said that you can't do this job, they're basically terminating instead of offering you any other jobs, which I would agree doesn't sound right. If what occupational health has assessed is that you have a disability, then your employer would need to try and make sure that they could accommodate your needs within that role. And then, yeah, okay, yeah, you do have a disability. Beyond that, yeah, they can't just terminate you. They would really need to work with you there. And they would also need to look for any other way that they could work with you. Have you, it sounds like you're pretty far down this, Nomi. So you've done a data subject access request. Great job. It sounds like I've been off for a year and you want to work. Well, yeah, I mean, like, why are they? Have you moved into ACAS early conciliation? How far have you taken this, Nomi? And whilst you're answering, I'm going to go back because I think Benny's got the rest of their question in. And I'll come to you next, Ibby, over on YouTube. So tell me this, if an employee sends a strong appeal and then tells the employer to without prejudice, and they accept appeal but say nothing about the 5-day time frame, should I wait? So if they accept the appeal, they might be trying to avoid settling with you, and it sounds like they might want to try and just reestablish the status quo, Benny. Timeframes in settlement negotiations are pretty made up, and an employer might view it as made up. but you would expect, especially if you're staying in the role, even temporarily, you would expect them to come back to you with an answer. So if they've passed the 5-day deadline, even if they have upheld your appeal, just because an employer upholds your appeal doesn't mean that they haven't done something illegal, or you might not want to still leave. So you're more than welcome. Of course, you can go back and say, look, do you want to negotiate a without prejudice offer here? So yeah, I think you're absolutely right to push it. Right. So Nomi is saying, I'm panicking. I work so hard to get where I am. Other retired members working 16 hours. I asked, could I? And they said, no, the service needs the 30 hours. Yeah, Nomi, your employer needs to be really careful when you have a disability to not. Oh, it sounds like if you're a band 3, I'm assuming this is something to do with the NHS. Your employer can't just ignore the fact that you have a disability and then sack you. If you haven't already, it sounds like ACAS early conciliation might be the right next step for you. And if you want specific feedback from Vala on how strong your case might be, and if you want to push it, that's what our merits assessment service is for. So basically you upload some information about what's happened, you add a little bit of context, ask any questions that you have, and then one of our coaches will review your information, have a call with you, answer your questions, and then give you an idea of how strong your case might be. They said termination of contract in 8 weeks if no job found. Yeah, that's so stressful. Nomi, I'm so sorry that you're going through that. That sounds so incredibly stressful. I can't, so ACAS early conciliation definitely is the next step if you want to escalate that. And if you do want some support from us, the merits assessment tool, which is the one that's in our bio, that's probably what I would suggest. Okay, so you do have a union and they say, await the SARS report. I mean, the thing is, don't forget about your 3-month deadline. And SARS, there's no extension of that 3-month deadline for waiting for a SARS report and all that kind of stuff. So I would look at ACAS early conciliation next. Okay, I'm going to answer a couple questions on YouTube and then I'll come back to TikTok. Okay, so Ibby says, can you tell me about preliminary hearings? I got informed that I would need to disclose all my covert recordings at the PH, and if I don't, I could get a cost order against me and that the respondent won't be able to provide better particulars if I don't declare it to the judge. Is this correct? I'm really worried. Ibby, who told you this? So you need to disclose. So you have claims. Your respondent has answers to those claims. You say what happened, and I'm presuming you have evidence to back up what you say has happened. And it sounds like they're trying to understand just how much you can prove. But if, like, it's one thing to say, these are my claims, and I'm not going to tell you why I'm making those claims, which I'm presuming you haven't done. And it's quite another to say, these are my claims, I can back them up. Respondent, what have you got? Typically, I would not expect you to need to disclose any evidence until the disclosure process kicks in, which is after the preliminary hearing and before the final hearing. And that's when you say, you give a list of what you have, and then you exchange that information. You exchange those documents. And typically that's a very formal process. The exchange happens at a particular point in time to try and not disadvantage either side. So yes, who is telling you this, Ibby? Is it the other side? Because I would personally not recommend you exchanging evidence until the tribunal tells you to exchange evidence. Okay, right, a question over here on Adam. Oh God, goodness. Okay, one of my teachers said that they got fired because they asked about a safety issue. Is this even legal? Good question. Well, probably not, because it sounds like they got fired for whistleblowing, and whistleblowing is protected. So what you would want your colleague to Google is the term protected disclosure, and that's when they have complained about something that fits one of the 5 or 6 categories of protected disclosure, which is either a health and safety issue, it's in the public interest, fraud, a few things like that. And then if they suffer a detriment because of that protected disclosure, that's illegal. and that is whistleblowing. That's under the Whistleblowing Act. So yeah, the term I would search for is protected disclosure whistleblowing to see if what they complained about would fit into that category. Okay. Right. Nomi, yeah, sorry, I've talked about Nomi. Adam, I did an amendment to include final written warning. However, judge didn't really read info and didn't allow the amendment. I did the EAT, but they have rejected my amendments. Oh, Adam, I'm so sorry. The bundle includes my final written warning paperwork, and I've written my final written warning. Witness statement of a witness. Can I bring back up my final written warning in the final hearing? If the final written warning is in the bundle, then absolutely you can. So you've got two things that you can do in a final hearing, Adam. It is you can cross-examine based on what's in the bundle, and then you can also submit your own. So after cross-examination, you can put out your case, kind of like a skeleton argument or something. I'm trying to remember the exact term. It's in our cross-examination webinar. If you watch the cross-examination webinar, you'll see our coach, Samira, talking through how you lay out your case towards the end. So yeah, hopefully. But if something's in your bundle, even if the tribunal is like, I don't really get this, if it's in your bundle, cross-examine based on it. Make your point. It sounds like they're not getting the point yet. Make the point in the cross-examination. Ange says, I have a remedy hearing next month. Oh, that's exciting. A remedy hearing, Ange. I have a remedy hearing next month, and I'm not sure what to expect, really. I'm aware that I could be asked questions again, but what sort of questions should I ask on the other side? Okay, so great job, Ange, because a remedy hearing, for everyone who doesn't know, means that Ange won. Yay! Ange won at least some of their claims. So that's like huge. Like let's give them some love hearts. Huge, well done. Okay, so a remedy hearing is basically determining how much to award you for. You're getting some claps and stuff on TikTok, and so it's determining how much to award you, and what they're going to be assessing at the remedy hearing does depend partially on your claim. So, for example, I'm assuming, Ange, and you can let me know, I'm assuming that maybe discrimination's involved and there's maybe a injury to feelings aspect to your claim. You're getting even more love hearts and claps and stuff on TikTok. So if that is the case, then part of a remedy hearing is going to be really understanding the impact of discrimination on you to properly assess which vento band you would fall under. And in some ways, in that way, if that was part of it, you can expect cross-examination again, because we talk about this in our injury to feeling webinar, which I would highly recommend that you go and check out if you're trying to get ready for that part. So for an example, you might say, I was very distressed as a result of this thing that happened to me. And okay, cool. So you Ange won for constructive dismissal and a failure to make reasonable adjustments. So constructive dismissal will probably be the basic award. Past and future losses. Failure to make reasonable adjustments would probably include an injury to feelings component, because that's injury, because that's a discrimination claim. So what they're going to do is say, well, it doesn't seem like you were all that upset because you got another job pretty quickly, for example. So expect another cross-examination and refer back to anything that you put into your bundle about the impact that this had on you, including your witness statement. Oh, Seuss is saying, well done on winning constructive dismissal. That's a really tough one. Okay, so you did include injury to feelings in your schedule. Basically, what you're going to find at a remedy hearing is gentle, like a range. It'll be gentle to strong interrogation of the impact that this had on you to determine the injury to feelings amount. And do expect cross-examination. And I would suggest, and any evidence that you can point to in the bundle, go back in your bundle, go back in your witness statement, anything that's in there that can show the impact that it had on you, just keep referring back to that. And that's what the other side will be looking at as well, as they try to lower the amount of losses that they have to pay. I hope that helps. Okay. Right, let me scroll back up and see more questions. The respondent missed many case management orders. The judges extended the deadline and now they have missed them again. I need my hard copy so I can complete. You're very welcome, Ange. I need my hard copy so I can complete my witness statement. Now my case management order will be late. Okay. You know, what you could do, Misha, is like, if you think that the judge is getting tired of this, you can always ask for an unless order, especially now that they've missed a second deadline. So an unless order is kind of like an or else order. And so that's saying, unless you meet this deadline this time, this third deadline that we have given you, then we're going to strike out your case or something like that. So you could request an unless order. We have a template for that you could use for that. The other thing that you can do is, if they're going to make you late, you could actually file for an extension, and you can say, you can request an extension and say it's specifically because the information has not been given to me on time, and so I am unable to do my part. And that's really that's one, you doing what you're supposed to do, which is ask for an extension. But two, it's really you highlighting how they're holding you back because they keep missing their deadlines. And you could actually do both. You could ask for an unless order and request an extension at the same time, just to highlight that they're playing silly buggers, basically. I hope that helps, Misha. Xavier says, I've just started ACAS early conciliation and wondering if at this point I name what I think I have a claim for, i.e. indirect discrimination, automatic unfair dismissal, victimization, and injury to feelings. Short answer, Xavier, is yes. You don't have to get too specific with it. You're very welcome, Misha. You don't have to get, like, if you know that you think those are the claims, there's no harm at this point in naming those claims, because if they choose not to do a reconciliation, or if they choose to ignore it completely, then they're going to see those again pretty quickly with the ET1 form itself. So it's not like you're revealing information that isn't going to be shown quite soon afterwards. So yes, I think, and what I would do is almost treat it as a practice round for the tribunal claim itself. Lay out, this is what I think the claim is, and here are the key pieces of information, the key events that back that up. And that's what your ET1 particulars of claim form will look like if you have to get to that stage. And that's what, the rest of your case would be based on. Show them how strong you think your case is right now. Either they'll ignore it because some people just choose to do that, or they'll look at it and say, oh, it looks like they kind of know what we're doing. Maybe we need to take this more seriously. But I don't see a lot of risk at this point in letting them know that that's what the claims you think are going to be. Okay, so let's get to the next question. Okay, so Nicole, great question, Nicole. For the preliminary hearing, do I need to submit my evidence bundle? And I see that Team Vala has answered this, but I just want to expand on that answer even more, Nicole. I'm assuming that it's a case management preliminary hearing that you're going into. That's the one where they send you a case management agenda, and you fill out each of the little parts. And that one, the key thing that you want to prepare is the list of issues, but you don't need to submit any evidence. So I'm assuming that it's a case management preliminary hearing, and so I don't think, okay, good, yeah. So just so you know, and so anybody else knows who's listening, there's another type of preliminary hearing, and that's called the substantive preliminary hearing. And that could be on a number of different topics, but it's really like a mini hearing. And with that one, you also get a mini bundle that you need to submit evidence for. Typically, we see substantive preliminary hearings because of either someone having to prove their disability for the case to go forward, or someone asking for an out-of-time claim, or having to prove that a claim is in time. So either asking for an extension or arguing that a claim is in time. And in both of those cases, you do submit evidence beforehand. For example, medical evidence of your disability, or stuff about this stuff being in claim. So yeah, just useful to know. We, for everyone, we have packages that can support you for both of those types of preliminary hearings. We have a preliminary hearing case management prep package and also a substantive package. So, and that's where you work with our coaches to kind of get the agenda filled out or get ready for proving you have a disability in the disability impact statement or whatever else that might be. And I'm sure Meg, Team Vala, can link you to or point you to the right page on the website to have a look at that. Okay. Right, let me just scroll through. So those of you who have asked questions, and I'm taking a while, I promise I'm getting through them as fast as I can, and I will do my best to answer everything. Okay, so Benny's saying, I asked my employer to enter into without prejudice in 5 working days. They have accepted the appeal. Does that mean they ignored my without prejudice offer? I think, Benny, I think they're kind of hoping that this will just go away if they accept the appeal. The thing is, an employer accepting an appeal doesn't mean that the illegal thing didn't happen in the first place, and it also doesn't mean that they're going to do anything about it other than just accept an appeal. So if you're trying to get a settlement, the illegal acts that you believe happened still happened, and accepting an appeal doesn't make that go away, especially if they're not actually putting any action into place. No compensation, no like moving a manager, whatever it is, or changing the behavior that happened in the first place. So yeah, absolutely tell them, hey, deadline's up. I'm going to go to ACAS early conciliation. Thank you for accepting my appeal. But at this point, you know, like accepting your appeal almost is like they admitted to it. But unless they're going to admit to it and do something to keep you from taking it to tribunal, what are they doing? Like, it makes no sense. So yeah, like absolutely push them on this, especially if you're looking for a settlement. Kat says, I'm from the States, but I watch all your work rule videos, even though they don't apply to me. Oh, thank you, Kat. You're learning a lot about UK employment law. Okay. Right. Should I? Yes. So Nicole asked about witness statements and schedules of loss. Both of those do not come to a preliminary hearing either. Either type of preliminary hearing. Both of those happen afterwards in the case management orders, which are issued after the preliminary hearing finishes. And just focus on your case management agenda. Absolutely. Okay. So Antoinette says, hi, I am being harassed at work and I don't know what to do. Oh, Antoinette, I am so sorry. I'm so sorry. So I'm assuming that you mean sexually harassed. And I'm just going to clarify why I said that first. Because there's a lot of different ways, unfortunately. There's a lot of different illegal ways to harass someone. One of them is if you are being bullied, belittled, degraded, any of that because of your protected characteristic. So for example, if someone is being bullied because they are gay, legally that is called harassment in the Equality Act. And then there is sexual harassment as well in the Equality Act. And I just wanted to, you mean abusive and controlling behavior? Okay. It sounds like, I'm so sorry you're dealing with that. So what I do on these videos and these lives is I try to help people understand when the bad thing that happened at work might have a legal element to it. Because if there is a legal element to it, that means you have so much more leverage than if it's just immoral but not illegal. Oh my goodness, stalking as well. That's when my goodness. So in that case, it sounds like, especially if stalking getting added in there, it sounds like this probably is happening because someone's obsessed with you. Is it someone of a different gender? Do you think this is related to your gender? And I ask because being bullied, belittled, humiliated, etc., because of your protected characteristic is illegal. And if you're verging into the stalking territory, is this happening from one person? One person is doing it to you, or is it a group of people doing it to you, Antoinette? But actually, that doesn't even matter so much as if you think that is happening because of a protected characteristic. So if you think you're being targeted because you're a woman, for example, then oh goodness, I'm so sorry that more than one person is doing that to you. This is awful. It sounds like that could be harassment under the definition of harassment in the Equality Act. The other thing that could be happening, well, one, if there's stalking involved, this could be a criminal matter. And I don't have any expertise, I'm afraid, in the criminal side of that, but I would advise you to phone up Citizens Advice probably and ask them about that, because that's totally not okay and very messed up. On the employment law side of it, have you raised a complaint about this at work? Have you told your manager or told the company that you think that you are being bullied or stalked or harassed? Okay. Whilst you're answering that, I'm going to answer a couple more questions. Actually, you've just answered. Yes, I have. And have they taken it seriously? Have they done anything about it? What has their response been? Okay. Right. Michaela says, I'm going to answer Michaela while you tell me how that went. Hello, my employer has accused me of making an extra cost on my phone bill of $8,500 when asked more info. They said that there is no way of proving that. Can that be constructive dismissal? So did they tell you that you spent £8,500 extra on a phone bill and then dismiss you? Is that what happens? Antoinette said, I would get the police if it gets worse. Absolutely, Antoinette. That is a very sensible thing to do. I actually think in your case, Antoinette, this is probably more of a criminal matter first than it is an employment tribunal matter. I mean, it could be both. But yeah, yeah, they can sack you. And it would almost certainly be illegal if they're sacking you for having raised an issue. So, Antoinette, the thing that I would Google if I was you is Equality Act victimization. Because, and this is for everyone, if you have raised a complaint at work about discrimination happening, not just like any of the 6 types of discrimination, including harassment, including non-sexual harassment, both types, if you get punished for having raised that complaint, then that's illegal and it's called victimization. So yeah, I would Google that and see yeah, so see if that applies to you basically, or you think that might apply to you. Okay, I'm still trying to understand. They put a gross misconduct in 2 weeks. Michaela, did they, if there's no proof, then that, I don't know if that's a constructive dismissal or just downright unfair dismissal if they dismissed you. Unfair dismissal is dismissal if you've been employed at a company for over 2 years, dismissal that does not follow a fair process or have a fair reason. So if they fail on either one of those, it's unfair. So if they dismiss you because of a phone bill and they can't provide any evidence that they don't provide any evidence for that, as long as you've worked at that company for over 2 years, that would probably not count as a fair process. Even if, like, they could have every legitimate reason in the world to do it, but it have to follow a fair process for it to be a fair dismissal. Is it possible to stop a dismissal, like with an injunction? That's a good question, Casey. I'm not aware. So I am aware of the protective, not the protective award. There is a very narrow set of circumstances where you can ask the tribunal to force the employer to continue paying you even after they've dismissed you, because the dismissal might be illegal. Now, that actually only applies to cases where you largely where you were union organizing. In those cases, if they sack you for union organizing, you can apply for them to have to keep paying your salary until it actually gets to tribunal. But it doesn't apply in most cases, unfortunately. So I'm not aware of anything beyond just that one circumstance where you could stop a dismissal or still get paid past a dismissal. Right. Next question. Employers do clearly not put in the writing. Once I started asking for written evidence, the employer got it irritating and started dismissal protests based on lies. Yeah, so this is an important thing to remember. So just because an employer doesn't write something down doesn't mean that it didn't happen, and doesn't mean that you can't prove it. I talk all the time about contemporaneous notes. And contemporaneous notes are the notes that you take about what happened, and contemporaneous means in the moment. So you take them as quickly as you can after the thing happened, because that counts more as evidence than a note that was taken 6 months later about your recollection of what happened. So even if they're not writing things down, if you're writing it down, what they told you, that still will count as evidence. So don't forget that, if that makes sense. If you raise a complaint, are you required to state the reason why? Yes. So Joe, I would recommend that you have a look at the ACAS Code of Practice for grievances. That is the formal process. That is the process that every employee and employer in the UK need to follow as a minimum for raising complaints. And then it goes into how your employer deals with the complaints. So what you should expect when you raise a complaint is that your employer is obliged to investigate that complaint. And by investigating, they need to sit down with you and ask you what happened and ask for your reasons. And so typically when you're raising a grievance, the best thing to have is actually those contemporaneous notes, because they'll want to know the who, what, where, when, who said what did they say, where were you, when did this happen, etc. So the more you can go in with that information, the less stressful that grievance investigation meeting will be. And it feels like you're being grilled, but they actually do have an obligation to ask you for more information. Otherwise, they would be violating the ACAS Code of Practice. And actually, if you don't raise a grievance and try to go straight to tribunal, for example, you would be violating the ACAS Code of Practice. And either way, if you win or if they win, if you win, for example, in an employment tribunal, but you didn't follow the ACAS Code of Practice, they could actually reduce your award by up to 25%. And if they didn't follow it, the tribunal could increase your award by up to 25%. Okay. Let's see. Next question. Because I have spoken up regarding sexual assault, I now am not giving career progression. Can I mention this in my preliminary hearing? Absolutely, Nicole. And I think, yeah, Team Val has replied. Google Victimisation Equality Act. That sounds sus. Okay, Bobble's here. So for those of you who don't know Bobble has also won their tribunal case. Harassment related to sex. During the tribunal, it was obvious that the trust had supplied false information to my regulator. They didn't dispute this. I expected them to it finally came out. They didn't change it. I've asked repeatedly for them to change it. Oh, goodness. Sorry, I'm trying to get this straight. I asked repeatedly for them to change it. They won't. So I want to raise a claim of victimization relating to the ongoing refusal to correct the way that they have supplied my regulator. Unfortunately, my union won't help on this one, so I'm on my own. Oh, Bobble, that is so awful. I'm so sorry that you're having to still go through this because they're still trying to... I mean, that absolutely sounds like a victimization issue. I mean, totally. Even after you won your claim, they're still trying to punish you. It's so not okay. Okay, next question, next point. What do you think about an employer deducting pay for property damage after an accident at work? Good question, Suze. So there are very few circumstances where an employer can legally deduct from your wages. And those ACAS actually lists those reasons. So I would definitely look at the ACAS website. I believe that's who lists it, or phone them up. Usually when deductions have been made, they're not legal. There's very few times when you can dock an employee's pay legally. There are some circumstances, but not many. So, and especially if it's an accident at work, I mean, they would need to be ironclad that they didn't have any part in that accident at work. Yeah. Okay. So yeah. Okay. It was a valid coach who said to me that I needed to disclose them. Honestly, I really need to. Do I really need to at the PH? Good question, Ibby. So first of all, a valid coach knows more than I do about the exact details of a preliminary hearing. What I don't know is if they have to disclose, if you have to disclose that you have evidence, or if you have to disclose the evidence, if that makes sense. And I would double check that with the coach. My understanding, based on your question earlier, was that you were asking, do I have to show the recordings or bring the recordings to the preliminary hearing, which I don't think you need to do. But disclosing that you do have the evidence might be something else, and I would defer to the coaches on this one. But I don't think what they're suggesting. Yeah, they suspect that I have them. I would clarify with the coach, are you saying that I need to actually take the recordings to the tribunal, or are you saying that I need to just disclose that I have these recordings? Because you are going to have to get permission from the tribunal to even use them. And so what your coach might be saying is that the PH is the time to get that permission. Again, I don't know. And I will defer to, definitely defer to the valid coaches on that one. Okay. Right. Next question. Can I take my work to tribunal for making me come into work with COVID? Mrs. Wook, I think that there has been some test cases on this, and I think the answer is you probably wouldn't win a tribunal claim for this. If the question is like a whistleblowing question, for example, of like in public endangerment because you'd be infecting other people, they asked me to just wear a mask and not do 90% of my scrubs. I'd need to actually, it's a good question, Mrs. Wook. I need to go back and look at the case law, but I do know that there have been some specific cases about this. And so I would suggest, as a starting point, if you want to know, I would go to the Employment Tribunal decisions website on gov.uk and type COVID into the search box and see what other cases have come out of this already. It's a pretty new area, and there are probably going to be some law firms who have written about it on their blogs as well. And you should be able to find an answer there, but off the top of my head, I don't know the answer. I'm so sorry. I have been asked for an idea of what I'm seeking in terms of settlement, including breakdown of any monetary amounts by the ACAS consultant. That's totally normal. And I have just started ACAS Early Conciliation. Do you have a suggestion of what research I need to do in order to get a good understanding of that? I'm aware of the banding for injury to feelings, for example. Meg, there's a question in TikTok about ordered a webinar, but the password doesn't work. Can you jump on that one and maybe DM Lida? So Xavi, two things. One is we have a free webinar on our website called How to Settle with Your Employer. I would recommend that you watch that because I do talk through some of this in the webinar. If you just go to the webinars page on our website, you'll find it there, and that one's free. But at a high level, what I would suggest that you research is there are some standard awards, or what are they called? The word will come back to me. There are some awards, basic awards. So for example, unfair dismissal has a basic award. And so you would just know that particular claims have particular basic awards, and those have online calculators. So you can just use that for that particular type. Then you would then look at past losses and then future losses. So past losses is just take it from the time right then. So as of today, in the past, because I was dismissed or because these things happened to me, I didn't get the promotion, I was dismissed, I've been off sick and I haven't gotten anything but statutory sick pay. This is the amount of money that I have lost if this bad thing hadn't happened and my life had carried on the happy path. So that's past losses. Future losses is from this point onwards, maybe I'm still unemployed, or maybe I'm unemployed, but it's in a job that doesn't pay as well or have as many benefits or something like that. And I think it might take me another 6 months to get another job of equal amount, or maybe a year. So future losses would be the difference between what you would have earned on that happy path versus what you're going to be earning in the future, and when those two would merge again. So that's a future loss. And then you have injury to feelings, which you're already aware of. And if you wanted to know a lot more about how to price an injury to feelings claim, you can watch the webinar on that one. So basic awards, past losses, future losses, injury to feelings, if it's discrimination, which yours is. And don't forget, in past and future losses, benefits, holiday time, pension, bonuses that would have normally been paid, and promotions that you would have gotten, all that kind of stuff. All of those count for past losses as well. I hope that helps. Workplace investigation ended 8 weeks ago. Work still hasn't gotten in touch with me yet. Oppression? Certainly not okay, Star. If you're not already chasing the hell out of them, I would be chasing the hell out of them. And don't forget about ACAS early conciliation and the deadline, the 3-month deadline, because that doesn't wait for them to come back. That them coming back has nothing to do with making sure you meet your deadline. Can I use a WhatsApp voice note as evidence, or do I need permission? So generally, you're very welcome, Xavier. Generally, WhatsApp can be included as evidence. The way that the tribunal typically thinks about this is if your employer typically uses WhatsApp as a communication method with employees, then it's fair game. If it's not regularly used, then it's going to be a little bit harder to ask to try and make it evidence. But if you and your manager, or you and the company, chat back and forth about what's on WhatsApp regularly, or if it's the typical way that you call in sick, for example, or something like that, then that makes tons of sense to include in an evidence bundle. They might fight it, but then you would have the ability to say, look, this is how we communicated. It's not my fault that they decided to use WhatsApp. So I hope that helps, Jordan. And typically, by the way, audio recordings almost always are submitted as evidence as a transcript. Typically, it's not the audio recording itself that goes into the bundle. It's an agreed transcript that both sides have listened to and agree that the transcript is accurate that goes in. Okay, I got my direct discrimination admittance in writing today. Next up, tribunal. That's amazing, Jody. Huge well done. Huge well done. You're very welcome, Jordan. So Julie, can I request text messages from personal phones as part of a subject access request? Same exact answer for you, Julie. So what will happen, especially on subject access requests, is they will push back and they will say, no, that's personal. And again, if it is part of the way that they communicate with you, then it needs to be included. Can a former employer take bank holidays from final holiday entitlement? So your employer is required to give you a number of statutory holidays, Red Riding Hood, and they don't have to those don't have to be bank holidays. They just fit in as the bank holidays. But if they are taking holidays from you that takes you below the statutory holiday entitlement, that would not be lawful. If they are removing holidays after you've but still giving you enough to meet the statutory requirement, then that's probably okay. Can an employer fire you for supporting Palestine? That's a really interesting question, Boris. There's a few different things that would be in play here. One of them would be whether or not the way that you voice your support for the Palestinian people would make anyone else feel as if you are creating a offensive, humiliating, degrading environment, because that could be harassment of someone else, for example, a Jewish person. Political, strongly held philosophical beliefs can be protected under the religious category and the Equality Act, but usually the examples are usually things like, veganism, for example. It would need to be a big part of your identity. So so it could potentially be under belief discrimination, but you would need to really show that it was a deeply held belief that's a part of your kind of fundamental identity. Dan has preliminary hearing in the morning and he's nervous. Can we all give Dan love hearts? Oh, well done, Dan. Just remember, the key thing is always with a preliminary hearing or any hearing, remember that you can ask for breaks. Remember that you don't have to answer every question immediately. You're getting lots of love hearts on YouTube as well, Dan. You don't have to answer questions immediately. You can ask for the judge to explain to you if you don't understand something. And the judge is trying to understand what's going on. So, you know, it's okay to take a break. It's okay to ask questions. It's okay to take a beat. And if the respondent throws any last minute shit at you, you can ask for a 20-minute break and say, oh, judge, I need 20 minutes just to read through this because obviously I didn't get it until now and I need to prepare. So don't worry, breathe, ask for a break, ask for time. Sayad's saying, look, lucky Dan, I'm still waiting for mine since 3 months now, ghosted by the Employment Tribunal. I'm so sorry. Like, some of these tribunals, it really does depend so much across the country how these tribunals are, how fast they're going, or slow in your case. I'm a community carer. The boss won't pay more mileage for picking up people that don't drive. Kimberly, that's very cheeky of them. That sounds like part of your employment. Kimberly, is that so I remember reading about the mileage things for carers. Are you picking them up after you have started work, in between jobs, in between going to different houses, or are you picking them up before you start work? Because from what I remember of the information on the mileage, I think that matters. So if you started work and then you're going between jobs and they're not paying you to pick up the next person to do that, even though that's what they're asking you to do, that almost certainly should be mileage that they pay. If it's before, are they requiring you to go and collect that person? Because if they're requiring you to go and collect them, I can't see how they can argue that that's not them adding a work duty to you and then the mileage getting included. So if you have an option and you're choosing to do it, I don't know if you would have to be paid the mileage. But if you don't have an option and you're told that you have to do it, I don't see how they're justifying that. And I do think that this is a good question to ask ACAS. Can I invite witnesses before filing my ET1 particulars of claim? It's good to try and get a witness lined up. They say I already get mileage. Are they paying you the extra mileage to go and get the person? So let's say it takes you an extra 20 miles. Are they paying you for the extra 20 miles? It's good to get witnesses lined up, but they don't actually have to do anything until much later on. So let's say someone says, yes, I will be a witness for you. That's all you need at that point. The next time that this will come up is actually at your preliminary hearing, when the tribunal asks, do you have any witnesses? And then you can say, yes, I have a witness. This is their name. And then they still don't have to do anything for ages. And then towards the end, towards the final hearing, you will have a case management order that asks for their witness statement. And then that's when they actually would, well, this is typically, that's in England and Wales. In Scotland, they don't have to do a witness statement. They just rock up on the day and say what happened. But in England and Wales, they would write a witness statement. They would then come to the tribunal, and the tribunal would, and then the other side would cross-examine them or something like that. If their lawyer mistakenly sends documentation that they have previously withheld, could this be post-termination victimization, and would I have to submit a new ET1? Casey, help me understand how it's victimization, because I don't see the connection with victimization quite yet, but I'm sure it's just because I don't understand. Yeah, I can't see, Kimberly, how they're not paying you that extra mileage. It's part of your job. Yeah, I would phone ACAS about this one. I think they could give you a clear answer that you could then take to your boss and say, I've phoned ACAS about this. But I can't see how they're justifying that. But I would double check with ACAS, because they'll be able to just tell them what to do. Can your employer force you to be a witness? Your employer can't, but the tribunal could. So if you want someone to come as a witness, if either side wants someone to come as a witness who doesn't want to come, and the judge finds that it would be essential for them to do that, they can do what is called a witness order. You would request a witness order, and that would order the person to come. And it's just like any other trial. It's just like any other court. If you don't come, you're in trouble, like legal trouble, like jail trouble. But typically that doesn't happen. Typically someone says they'll be a witness. Your employer can't force you to be a witness, to my knowledge, though. What if the court orders a witness to attend? Do they have to write a witness statement, or will I just put questions to them? So it depends on Scotland or England and Wales. In Scotland, it's rare to have a witness statement written beforehand. They just arrive. Typically what happens in Scotland is that let's say the witness is for you, you would then ask them questions to get out what happened and make sure that that's on the table. And then the other side would cross-examine them. If it's England and Wales, then they would write the statement before, submit that as part of the evidence bundle, and then you wouldn't do the first part where you ask them questions because we already know what they're going to say about what happened. They've already said it in writing. And then afterwards, it would just be that the other side cross-examines them. I think the judge, yeah, so I hope that answers the question, actually. Can a family member be a witness for assistance and care they provided to a disabled claimant? Tina, I could see that coming in two ways. One is proving a disability, and two would be as part of an injury to feelings claim to show the impact that the discrimination had on you. And yes, in both cases, you can request a family member to be a witness. The judge might not take it as seriously because obviously they have a vested interest to support you, but in many cases, the judge will allow it and will take what they say into account. They might just not put as much weight on it because of the potential conflict. Hey, I sent you an email and message on TikTok, but I've not had a reply. It's been a couple of months. Jordan, can you send an email? I don't know did you email hello@vala.uk? Because I would have thought that we've got a whole team that monitors that inbox. We don't have as many people monitoring our TikTok. So if you send us a TikTok message, you're not going to get a very fast reply and it could get missed. If you send us an email to hello@vala.uk, you're much more likely. We have lots of people answering that. Okay, so we've got 10 minutes, 10-minute warning for everybody. What can you do about false documents created and used as evidence against you in a grievance? It's awful. I see all kinds of people saying that this is what's happened to them, and it's so frustrating. The first thing to do is just say, I think this document is false, and say that in the grievance, and then if you get into a tribunal, after the preliminary hearing, you can go to the case management orders. There is the disclosure process where evidence has to be exchanged. And if they send a document and you think it's false, you can ask for a specific disclosure order from the tribunal, which is basically where the tribunal says, hey, they think this is false. Can you search to make sure that you've got the right document? And so basically you're using the court to put pressure on them to give the real document. And remember, you can use things like metadata, things like that. And you can cross-examine on the day, on the final hearing. Often all of this stuff has to come out right at the end. And you go into cross-examination and you say, page 103 of the bundle, this document says this. And they're like, yes, it does. And you say, Kim, are you aware of the metadata on page 103? And then you can use metadata or things like that to try and show that it is a false document, or you have your own version of the document, etc. All the respondents' solicitors have changed the day before the PH. Is this a tactic? I'm not surprised if it is a tactic. I see all kinds of crazy tactics, or it could just be like really bad organization on their side. I would say, Dan, if they are throwing last minute changes at you, do I need to know every legislation for the PH? I'm nervous I've not got the correct ones. No, the only thing you really need to focus on at the preliminary hearing, if it's case management preliminary hearing, is that list of issues. Everything else is pretty straightforward. And the judge will help you with the list of issues because you're a litigant in person. And they'll help you figure that out. And honestly, most judges, they have a way that they prefer laying out that list of issues. So they'll probably just take what you've got and fit it into their format. So yeah, don't worry that you're gonna have to cite tons of case law right then and there. And just they know that you are a litigant in person. Okay. Okay, so what I'm trying to ask is, if a witness who doesn't want to attend finally attends due to a court order, will they make a statement based on what I tell them, or make what I just asked and with them questions? It depends on whether or not you're in England or Scotland. Either way, you don't actually, even if they're a reluctant witness, the court will tell them to either issue a witness statement or provide a witness statement or attend about a particular topic. So they will say, we want your witness statement on the events happening on October 10th, for example. You're not going to be able to give any willful or unwillful witness any more information than that to direct them as a witness anyway. All you can really tell, you can't collude with a witness anyway. And so they probably will still have to submit a witness statement even if they are ordered to attend. Okay, so yes, the basic award calculator would not apply in your case because basic award is for unfair dismissal, not automatic unfair dismissal. In your case, you wouldn't have a basic award. That's the short version. The basic award only applies in cases of unfair dismissal and a few other things. So you don't need to worry about that one. Just focus on past losses, future losses, and injury to feeling. Okay, sorry, I'm just going to ask, an employer is refusing to do a full DSAR because of pending tribunal. What can I do? This is such a bullshit move from the employer. A tribunal has nothing to do with the data subject access request, legislatively, legally speaking, and vice versa. Data subject access requests are governed by the data protection law. Employment Tribunal is governed by, the Equality Act, the Employment Rights Act, etc. Those two things have nothing legally to do with each other. It's just that the DSAR is actually quite helpful for collecting evidence for an employment tribunal. But they cannot deny you your data subject access information because of a tribunal. And you can complain to the ICO and you can send back a strongly worded letter to say, this has absolutely nothing to do with the tribunal. My right as a private citizen to my data is nothing to do with ongoing court interactions elsewhere. So that's bullshit. Gave me conflict of interest. There's no fucking conflict of interest. Sorry. Sorry. No, there's no conflict of interest. Your right to your data is your right to your data. The end. Tell them that. That's so frustrating. I'm so sorry. I'm clearly getting het up here. Right. My appeal hearing is next week. I have a union rep attending on my behalf. How do appeal hearings work? Or do appeal hearings work? I mean, sometimes they work fee, but sometimes it's a motion that you have to go through in order to show that you have tried to go through all the motions and tried to make it right before you have to take it further. So I would not hold out too much hope for an appeal hearing, but I don't know your specific circumstances. Sometimes it's, sometimes the tribunal or sometimes the employer actually would benefit from going the other way in the appeal, and so they choose to do it, but often it's just a step that you have to go through that is very demoralizing to show that you went through it. Right. Danae, you are hilarious. Thank you. She got upset and started swearing. Was that me? Sorry about that. Okay. Right. It's good to see the passion. I've told them I'll request the tribunal order it and report to the ICO. Absolutely, Heising. Absolutely. Claire, as a new hire, I was told I couldn't be paid more because of another team member and took a big pay drop. Claire, I have found out I'm actually on the wrong job code. Can I claim a pay rise? The two things I would look into there, Claire, is breach of contract. If they said one job code and then put you on another, but I wouldn't go straight for that. I would just raise a complaint and ask to be put on the right job code if that was the code that you expected to be on and they agreed for you to be on. Or if it's something to do with, if it's a gender thing or any other kind of protected characteristic thing, I would maybe look at that. That would either be an equal pay or maybe a direct discrimination issue. But first, either way, whichever one it could be, a grievance is the next step. Can we discuss whistleblowing? So can I disclose to other employees about the discrimination or not? You absolutely can, Benny. And actually, you can't. The employer... Yeah, you absolutely can. Employers try to keep us from discussing anything with each other. They might... If you think that you are being discriminated against and you are asking other people, hey, can you provide evidence for me? Or did you see this? Do you know anything about this? Stuff like that. They cannot punish you for doing that. That's part of you just doing what you need to do in order to pursue your legal right to be heard for what you think has happened. And yeah, whistleblowing in employment tribunal is a very specific thing. So just make sure that it fulfills that criteria, because whistleblowing, there's a few words like whistleblowing, victimization, etc., that in layperson context means one thing, but in the employment tribunal means something very specific. So just double check that that is what you're doing. And I'm sure it probably is. Tina says, my employer did not provide me with the complete SAR data. My next move is to get the tribunal to force them to disclose evidence that they didn't provide. That's exactly right, Tina. That's exactly right. Okay, right. Let me just try and get one more question in before we go. When attending the tribunal, do I get paid time off or do I need to use my holidays? Jazz, that is a great question, and I don't know the answer. Meg, can you take a note of that question, and I will see if I can find an answer and maybe do a video about it. That's a really good question. Is it better to have a settlement via ACAS or a solicitor? If you really want someone fighting for you, use a solicitor, because ACAS has to stay impartial, and they just need to facilitate. But if you really want someone to represent you and fight your corner other than you, then use a solicitor. And what typically the way that works is if you do a settlement negotiation and the employer agrees to do a settlement negotiation, if they agree to settle with you, they will typically pay towards your legal costs, anywhere from about £250 to £500, something like that. So you can, lawyers will know what to do if you speak to them about it. They'll say, oh, we'll see if we can get this covered by your employer's costs. Does judicial mediation work, do you think? So judicial mediation is really interesting. I personally don't think that it's like the best thing in the world, because judicial mediation is basically both of you submit written information about why you think you should win and any evidence that you have. The judge reads everything, and then they tell you whether or not they think you're going to win. So if you are an excellent written arguer, it might be a good idea. But the whole point of judicial mediation is to save time. That time is in a hearing. And in the hearing, that's when you get to have your say. So if you think it's a slam dunk case and you've got bang on written evidence, it might be worth using judicial mediation to speed up the whole process. But if you think that this is really going to rely on you getting your point across as a human being to other human beings, I don't know if it's a great process. Judges are the scariest people in the world. They can be. It really depends on the judge. I've met some lovely employment tribunal judges, but I have heard about some very non-lovely ones. So it really does depend. Okay, I'm going to go. Thank you all so much. I will be here next Wednesday at the same time. I'm so sorry if I missed your question. So sorry. Injury to feeling witnesses would probably need to come in, Tina, and that would probably... So one thing I will say quickly, so for those of you who are asking about compensation awards at the end, like injury to feeling, things like that, put the evidence, don't just put in your bundle evidence about what happened to prove your case, but put evidence in as well about the impact of what happened, because that bundle counts for both. It counts for the final hearing and the remedy hearing. So you want the evidence for both in your bundle. So if you need someone to come as a witness to talk about how terrible things were, submit a letter, get that letter into the bundle now, if that makes sense. Okay, thank you all so much. See you next Wednesday. Have a wonderful day, and good luck, everyone, and keep going. See you later. See ya later.